welcome back to PSA TV. This is the Wake Up Call here. I am your host, Christy Kali Singh. We've recently seen a lot of retrenchments, possible retrenchments, and even hinting of retrenchments in this country from various sectors, but most importantly, the public sector. Issuing a call recently was the president of the All Trinidad General Workers Trade Union, Mr. Nirvan Maharaj, who joins us on the phone right now to tell us a little bit more about a statement he would have issued on this matter. Good morning to you, Mr. Maharaj.
Good morning to you, Ms. Kali Singh, and pleasant good morning to your listeners out there.
How are you this morning?
I'm fine, I'm good. I hope the same is with you.
I am. Okay, so let's talk a bit about a statement you released a little while ago based on legislative reform for workers. First of all, what would have led you to issue a statement?
Well, there have been over the past few, I shouldn't say months, but years, many workers being retrenched, employers taking advantage of workers in many ways. And I think the time had come when the trade union movement had to seriously consider ways and means by attempting to influence legislative reform in order to benefit the working class. And that is why I would have called for legislative reform with regard to the Companies Act, to the Retrenchment and Severance Benefit Act, to the Industrial Relations Act, in order to ensure that workers are not unduly taken advantage of.
Yeah. I'm seeing here that your first point, your first recommendation was, like you're just saying, the immediate need for the simultaneous reform of the Retrenchment and Severance Benefits Act and the Companies Act in order to protect the workers and ensure that they are paid all benefits. Now, we all know that payment has been a major issue in this country in terms of severance, pensions. Your thoughts as a union leader on how the lack of payments has been for workers?
Well, the lack of payment is sometimes as a result of the loopholes or the lacuna, as you would call it in the law, by which companies could escape their financial obligations to workers. If you allow me, for example, within the Companies Act, if a company should go insolvent and wind up, workers are often placed last on the list of creditors for payment of monies that are owed to them. I am saying that we need to reform the Companies Act in order to place workers at the top of the list as a major creditor of all companies. And that is because of the work they would have given their work on their fair day's work for a fair day's pay. As it stands, I do believe that major creditors such as public utilities and banking institutions could actually stall any of the adverse effects on themselves by the wind-up, because their profit margins could act as a buffer, and also the government, in the case of public utilities, could act as a buffer. But the ordinary worker who is depending on a salary to survive, a month-to-month salary, he has no way of buffering his losses or his lack of an income in the event of a total retrenchment. And as such, he will be more in dire need of the financial obligations owed by the company to him. And therefore, he should be placed at the top of the list of creditors in the event of a wind-up. In addition, the Retrenchment and Severance Benefit Act, if I may, basically, if a company should retrench all the workers, which technically means that the company has basically wound up, there is no need for the company to pay any monies to the workers. And these things need to be reformed to place workers in a position where, in the event of a wind-up, they are able to get something from the companies.
Is it that you think that not just employees, but companies don't see the importance of, their workers?
Well, certainly I do believe that most companies, of course, if not all, would look towards profit maximization, and at the same time they would actually have the mindset of the olden days of economic policy, where when you dealt with the factors of production, land, labor, and capital, and entrepreneurs, you looked at the workers as simply labor, as simply statistics, You look at them without looking at them as human beings with emotions and feelings and problems and difficulties of their own. You simply use them as a tool of production. And until such points of views are changed in terms of how a company views a worker, we will always have the same problem. And that is why we need the Parliament of Trinidad and Tobago, the only place in this country where you could have legislative change being implemented. You need the Parliament to do so. And as trade unionists have always said, we could rant and shout and bawl and march on the streets and every Labor Day we go down and we give long, beautiful speeches. And at the end of the day, if we cannot influence Parliament, then we will always continue to do the same thing, expecting a different result. And that is why, as a labor movement, the time has come for us to come together and unite together to force legislative change in Trinidad and Tobago.
Now, I know you have been in the past very vocal about unity of the labor movement. How critical is it in this day and age going forward?
Well, it is extremely critical if we hope to assist the ordinary man on the street, especially in times when you have, so many economic changes taking place, where you have the advent of more contract labor, where you have people being retrenched willy-nilly, where people are unsure and insecure about their future. The labor movement must be united if we hope to influence change, and that is why I've always called for the labor movement to form itself into a political entity, or to form itself into such a powerful lobby that it could actually influence the direction of other political entities. At the end of the day, unless you have the power to influence legislative change, then we will always remain the same.
Let's move on to your second point, where you said that the reform of the Registration, Recognition and Certification Board is also needed since unions often face the daunting task of applications for the recognition process, which may possibly, as we all know, it's a lengthy process. And you've also said that in some cases being granted after companies have closed down. Tell us a little bit about that.
That is a fact. The process is extremely lengthy. There's a lot of procedure and checking involved. In other jurisdictions, a union could actually gain recognition of a company by sometimes a simple show of the hands amongst the workers. We have to find a way to make this process for the longest, at least 3 months. I myself would have had to threaten the recognition board, I remember in 2013, that I was actually going to call the names of all board members on Labor Day and speak about a company that I was attempting to gain recognition for. And the recognition board made a mistake on the certificate. I was unable to represent the company, and it was taking almost 2 years for the recognition board to rectify that mistake.
Wow. And so it's an error on their part.
On their part. And when I threatened that I will go and call the name of every board member, within one night it was fixed.
Wow.
And the night before Labor Day, I was given the certificate. So all these things we need to look at, and we also need to remove that concept where the recognition board is a law unto itself and a force unto itself.
Yeah.
Decisions of the board, we must be able to challenge decisions of the board, not only by the way of judicial review, but by the normal means.
What do you think is a good enough time frame for this process to be carried out?
You mean the legislative reform that we...
No, the recognition process.
I think 3 months is fine. I think 3 months is good enough for the company, for the board to be able to check the records of the company, to check the records of the union, simply to ensure that the workers are financial. And you could have a vote. You could have a vote within the company amongst the workers, or once you check and you see that the union has 51%, then that's fine. I'm not even calling for a change to the 51%.
Yeah.
All I'm saying is the process and the procedure needs to be reformed so that it does not take more than 3 months. I think 3 months is adequate.
Yeah, I think that makes sense. As opposed to 3 years, 2 to 3 years.
Indeed. And, I would have also called for that indemnity fund to be set up.
Yes.
in the event of a wind-up of a company that where workers could be paid terminal benefits. And it's similar to what we have happening in certain countries in Europe, Germany, for example, where there's actually a fund that in the event of the wind-up of a company, the fund is secured by the government and workers are able to be paid a salary or the financial obligations owed to them so that they are not adversely affected because of the wind-up. And we need something like that in Trinidad and Tobago, especially in light of the steel workers and so many other persons who have been retrenched without receiving any benefits whatsoever.
I mean, if you look at the manner in which some companies deal with retrenchment, it makes you wonder if they even had their workers in mind. When you speak about the payments, and now when a company is wound up, the workers are often the one who feels it most.
The workers are the ones who suffer the most, and the reason for that is that many workers are dependent on that month-to-month salary to survive.
Yeah.
Unlike an entity as a company, or unlike a bank, a banking institution, unlike a public utility, the fact is a worker who is dependent on a salary to survive will always face the brunt of any retrenchment, any wind-up, any insolvency. You see, at the end of the day, remember, workers need to buy groceries, they need to pay rent, they need to pay mortgages, they need to take their children to the doctors, they need to take care of their children's educational interests. And to a very large extent, employers fail to look at it that way. And that is why workers continue to face the burn. And if I may be so bold as to say, maybe the time has come for trade unionists, many trade unionists, to stop studying about what board position they could get on tripartite boards and study about coming together to demand legislative change from the government and the opposition, who together in parliament could implement this change. I have called and I have issued the call before. I think every single trade unionist should immediately resign from all boards that they sit upon as a show of protest because of the lack of government's response to this call for legislative change. Because if we don't, then the workers will always be in trouble. We cannot call for change, legislative change, and then the minister is appointing this one and that one and this one and that one to boards, and we are serving on boards. The time has come for trade unionists to be willing to give up that stipend that they get in order to serve the working class of this country. I myself, as you know, Christy, would have resigned from all boards that I sat upon.
Yes,
and my own officers would have done the same. Because you have to lead by example. You cannot quarrel with the government and cuss the government and cuss the minister, and the next day you are accepting an appointment to a board and shaking the hands of the minister. That is absolute nonsense. It is either you are in a war or you are not in a war.
Well, I mean, I think it comes down to who the individual is seeking the interest for, and I think it now brings into play a level of selfishness, whereas you were supposed to look out for the union members, but here it is, you're offered an opportunity, so you now see it as something very individualistic and something very selfish.
Before Petroshin was closed down, after we met with the Prime Minister, all the union leaders were there. And that is when I issued the call, I said, let us resign from all state boards, all tripartite boards, whatever boards we sit upon, as a show of protest. I even went so far, and I'm too old now not to say what I think. I even went so far as to say to my trade union colleagues, maybe the time has come for us to form a united front politically and challenge the incumbent parties in the marginal constituencies and let the chips fall where they may, win, lose, or draw. But the trade union movement must show that it's serious in its demand for legislative change. Because if we cannot unite together to get into parliament, or if because of the historical dynamics of this country in terms of elections and politics emerging from the 1950s, where the incumbent political parties are all short of certain seats because of the geopolitics of the country and certain bases, we could affect the incumbent parties in the marginal constituencies and force them to take us seriously. Unfortunately, and like I said, I'm too old not to say what I think. Unfortunately, I think many of my trade union colleagues have other things to study.
And speaking
In
about
addition to sitting on boards.
speaking about getting into parliament, we would have seen the opposition leader extending an olive branch to the trade union movement, but that's a topic we'll discuss later on, of course. But just to get back to what we were talking
Sure.
about, your fourth point was something that stood out to me, which was there must be a reform of the process of hiring industrial court judges, since this seems to be the purview of the political directorate, and linked to this is the urgent need for security of tenure of judges. We've seen hiring and firing and, various things happening in the judiciary system, most of which the average citizen does not know. Could you just enlighten us about that point?
Well, certainly. Even though industrial court judges are laymen, really, anyone could be appointed because of the political directorate. It is not to say that you are sitting in the criminal or civil jurisprudence. And therefore, to an extent, I understand why they may be treated differently. But at the end of the day, if you are arbitrating on issues, and if your jurisprudence and your jurisdiction is to deal totally with employment law and industrial relations matters, then you must be given, even though you may not be in the civil or criminal jurisprudence, you must be given the security of tenure. You must be made permanent in order to ensure that you know that you cannot be adversely affected as a result of the judgments that you give. And that is what I mean by security of tenure. We probably need to have an independent commission set up, an independent body who would be responsible for recommending the appointment of industrial court judges to the court, rather than having it fall within the realm, I think, of the Attorney General and the political directorate.
Yeah.
I do think perhaps even then, and in the press release I did say maybe, because of the fact that the court itself seems to lack that legitimacy, maybe we probably need to use the same system of appointing judges in the High Court of Justice with the industrial court. So judges there, even though they are layman judges, would certainly feel a sense of security, feel a sense of independence, and be able to give judgments based on the issues and the facts, rather than having to study how a judgment could adversely affect them.
Yeah. And your fifth point here says there must be reform to the Act to ensure that industrial court is able to enforce the awards and judgment it delivers. As it stands, the industrial court has no powers of enforcement, and judgments have to be registered at the level of the High Court and to become awards of the High Court and enforce that level. And you went on to say that it is very expensive and also undermines the jurisdiction of the industrial court.
It does. The industrial court, even though it deals with a separate jurisprudence, which is industrial relations, at the end of the day, if the court doesn't have the power to enforce its own judgment, if, for example, collective agreements are enforceable only within the realm of the industrial court, and if it is a breach, you have to go to the High Court as a breach of contract, not as a breach of a collective agreement. If the court is unable to pass punitive sanctions against employers who fail to adhere to the judgments of the court, then we are in trouble. And that is why the industrial court has become, to a very large extent, a toothless bulldog. Because once an industrial court judgment is appealed, it goes to the Court of Appeal, and workers and union now have to find huge sums of money in order to enforce it or to deal with the appeal. And if it is not appealed and the company still does not abide by the ruling of the industrial court, then the union has to register that judgment in the High Court.